There's no such thing as automatic custody in Australia. If someone told you otherwise, they are wrong. If you're separating or already have, you might be wondering what your rights are or whether you still get to see your kids. The truth is, it's not about your rights. It's about what's best for them. I'm John Boy. I've worked in family law for 17 years across parenting disputes, complex property splits, and international relocation matters. I also mediate and arbitrate outcomes for families who want to avoid court entirely. Over the next few minutes, I'm going to walk you through how child custody actually works, from parenting time and decision-making to consent orders and common mistakes that cause the most conflict later on. Let's start by clearing up the biggest misconception. There is no legal presumption that children live with one parent more than the other. The law doesn't give preference to mothers or fathers. In fact, the term custody is no longer even used in Australian legislation. What we now look at is parental responsibility and care arrangement. And the core principle that guides all of this is what's called the best interest of the child. Every parenting decision, whether it's made between parents at home or by a judge in court, is measured against this standard. There is no single checklist, but the Family Law Act sets out several key factors the court uses to determine what's in the best interest of children. Here are 4 that often carry the most weight. The first is safety. Here the court wants to know if the child is protected from harm, including exposure to family violence or neglect. Second is the child's own views. Depending on their age and maturity, the court may take their preference into account. Third is the history of care. Here the court will look at which parent has provided day-to-day care in the past and what routines the child is familiar with. And fourth, capacity to meet needs. This includes emotional, physical, and developmental needs, as well as practical logistics like availability. If you are thinking about what's actually practical for the child, like maintaining the same school routine, avoiding stressful handovers late at night, or making sure homework is supported during exam periods, you're more likely to arrive at similar conclusions. It becomes less about my week versus your week, and more about what's best for the child day to day. That shift in mindset often leads to fewer disputes and makes it easier to build an agreement that lasts. Now let's talk about a common source of confusion: the difference between responsibility and time. Parental responsibility refers to who makes the major decisions about a child's life. That includes choices about education, health, religion, and where the child lives. The law usually starts with the assumption that both parents share that responsibility. Parenting time refers to how child's week is actually spent, where they sleep, who picks them up from school, how holidays are divided. Shared responsibility does not automatically mean 50-50 time. The time arrangement could be equal, but it could also be 9 nights with one parent and 5 nights with the other. For younger children, a common model is a 2-2-3 arrangement. 2 days with one parent, 2 with the other parent, then a long weekend alternating. For older children or teens, it might be week about. Around 13 or 14 years of age, the child's views start to carry more weight, but the court still considers safety and stability first. Once you've agreed on how parenting will work, the next step is to decide how you're going to record that agreement. There are 4 main options. The first is a verbal agreement. This is a handshake deal. It's fast, flexible, and free. But the risk is that misunderstandings build over time, especially around holidays or travel. The second is a parenting plan. This is a written agreement, usually signed by both parties. It sets out the schedule, responsibilities, and any special arrangements. It's not enforceable in court, but it does show intent and can help resolve disputes. A good parenting plan will cover day-to-day care, birthdays, school holidays, medical decisions, and travel permissions. You can create one without or with a lawyer. The third is a consent order. If both parents agree on the terms, you can apply to the court to turn your agreement into a legally enforceable order. A registrar reviews it to ensure it's in the child's best interest. If approved, it becomes a court order even though no court appearance is required. These are common because they provide certainty without going to trial. And fourth is a court-ordered parenting arrangement. When parents can't reach an agreement on their own, the first step in most cases is mediation. This is a structured conversation facilitated by a neutral third party, usually through a service like Family Relationship Centre or a private mediator. The goal is to help both parents talk through the issues and try to find common ground without going to court. If mediation doesn't work, or if one party refuses to participate, the mediator can issue what's called a Section 60I certificate. This certificate is required before either parent can apply to the family court for parenting orders. It's essentially proof that a genuine attempt at resolution was made. Once you apply to the court for parenting orders, the court will review all relevant information. That includes documents, affidavits, any reports from psychologists or family consultants, and each parent's proposed plan. After considering the evidence, the court will make a decision and issue legally binding parenting orders. These set out exactly how parenting time and decision making will work, and both parents are required to follow them. If this arrangement breaks down for some or other reason, like one parent is not following the orders or the child's needs have changed significantly over time, you generally have two options. Either you can try to resolve it by informal agreement or by updating the consent orders through the court, if both parties agree, or apply to the court to vary the orders, which requires showing that there has been a significant change in circumstances since the original orders were made. This is known as the Rice and Aspelin test. If one parent is breaching the orders, you can also apply to the court for what's called a contravention application. This is a formal process that asks the court to enforce the existing orders and in some cases, apply penalties. The key point is that once orders are in place, they are not optional, but they can be revisited if things have genuinely changed. If there is a family violence or coercive control, the legal process changes. In these cases, you can go directly to the court and request urgent interim orders. These are temporary parenting arrangements the court puts in place quickly, usually to ensure the child's safety and stability in the short term. The court may also order supervised contact, where a parent can only spend time with the child in the presence of an approved third party. Protective conditions such as no unsupervised contact or limited communication between the parents, or restrict travel or relocation if there is a risk of one parent leaving with the child. The court will often request further evidence such as police reports, intervention orders, or a family report from a psychologist or social worker. If a psychologist report is prepared and you believe it contains errors or presents a one-sided view, you can raise concerns with your lawyer. In some cases, the court may allow the expert to be questioned or request a second opinion. The court's priority in these matters is the child's safety, where risks are identified that will usually outweigh arguments about equal time or shared care. Now, in terms of child support, this is assessed separately by Services Australia, but you will need a parenting arrangement to determine child support because it's based on two main inputs. 1, each parent's taxable income. 2, the number of nights the child spends in each home. Even if you agree on care arrangements, Services Australia will still calculate support based on their formula unless you formalise a private arrangement. If you want to include child support in a consent order, you can. That might cover fixed contributions or extra costs not included in the standard formula. Just keep in mind, no private agreement can reduce support below the government assessed minimum. Before I wrap up, I'll answer the last most common question when it comes to child custody arrangements, and that is, do you need a lawyer? For some families, this entire process can be managed without lawyers. That's especially true when both parents communicate well and the arrangements are simple. But if there is disagreement over time or decision making, safety concerns, complex financial circumstances, overseas travel, or prior court involvement, then getting help early often saves time and reduces stress. If you've already drafted a parenting plan or are thinking about one and you want a second opinion before formalizing it, you can book a confidential call with our team. There's a link in the description below. Thanks for watching.